Can bodies of water be granted personhood under the law? My name is Shayna Oakes, and I would like to discuss a novel but not so novel idea of granting water personhood in a court of law. Now, this area not only affects environmental law but federal Indian law as well, and there are three key points to this discussion that I would like to focus on. The first being the current water crisis in North America and around the globe, along with the Indigenous perspective on water. The second being how personhood has not always been just for people to have legal rights, but non-human entities as well. And third, which is the solution, granting water legal personhood. The world is not filled with infinite resources of water. In fact, the earth only has a finite amount of freshwater resources that are either running out or are currently being exploited by industry and other harmful man-made activities. Right now, nearly 2 billion people live in countries experiencing high water stress. Now, for time's sake, I will not be going into detail with some of these examples, but they are crucial in understanding the world's current condition. These examples include Cape Town, South Africa, where in 2018, residents were limited to 2-minute showers and 23 gallons of water per day per person. Chennai, India, on June 19, 2019, 11.2 million people went without drinking water. Other examples here in North America include Flint, Michigan, where residents are still struggling with clean water 8 years later, and the Montana River recently on April 2nd, 2023, where a train derailment spilled powdered clay and beer into the Montana River. Now, Native people are the most likely to have access issues regarding water and sanitation. The Neskantaga First Nation residents have been on a boil water advisory since 1995. The Grassy Narrows Nation has been dealing with water contaminants from the paper mill industry for decades. And the Navajo Nation, the Animas River system was polluted by the 2015 Gold King mine spill. Millions of gallons of hazardous mine waste leaked into their river system. According to Kelsey Leonard, who is an Indigenous Shinnecock woman and a legal scholar, the water crisis is a result of the Western legal system's failure to recognize the legal personhood of water. Because from an Indigenous perspective, water is alive, a confusing statement for those who participate in Western culture, but there are thousands of Indigenous cultures that believe differently. Water is alive because it is a part of nature, and nature is alive. It is moving and ever-changing. It deserves the ability to exist, flourish, and naturally evolve. Water is life and it is sacred, and we need to fundamentally change the way in which we value water. It is a resource we should not wait to realize is valuable when it's gone. Now, granting water legal personhood would allow for legal retribution in instances where natural bodies of waters have been harmed by some sort of human cause. Legal personhood grants the person the ability to be visible in a court of law, and our voices are heard as a person under the law, but this is not just a right that has been reserved only for human beings. For example, corporations have been given legal personhood and retain some protections under the Constitution. It goes all the way back to 1886, where in Santa Clara County versus Southern Pacific Railroad Company, the Supreme Court held that the 14th Amendment's Equal Protection Clause grants constitutional protections to corporations as well as to natural persons. And even more modernly, in Citizens United versus the Federal Election Commission in 2010, the Supreme Court upheld the rights of corporations to make unlimited political expenditures under the First Amendment, arguing that political speech rights do not depend on the identity of the speaker, which could be a person or an association of people. In Burwell versus Hobby Lobby stores in 2014, the Supreme Court held that the Constitution and the Religious Freedom Restoration Act exempted Hobby Lobby from aspects of the Affordable Care Act due to religious beliefs. Now, if corporations can be granted legal personhood and be offered constitutional protections, why can't a vital resource and a living body be granted those same protections? Granting bodies of water legal personhood would give water the right to exist, flourish, and naturally evolve, along with protection from pollutants, human-caused climate change impacts, and man-made contaminations. Now, the Supreme Court has not waived the idea of granting nature standing in court, but rather, in Sierra Club versus Morton, the court only ruled that currently under the law, the injury in fact test requires more than an injury to a cognizable interest. Granted, this means that currently, for nature to have standing, there needs to be injury to the party themselves seeking review. But if bodies of water were granted personhood under the law, there would be injury to a cognizable interest when there is human interference with the water's ability to flourish. Now, this is not a novel idea. In fact, there is a success story within the Western world, the Wanganui River in New Zealand, where in 2017, the Maori people were able to successfully advocate for the legal personhood of the Wanganui River. And now there are elected guardians from the tribes that can advocate for the river legally. Obviously, the river cannot enter into the court itself, but much like corporate entities, there is representation that can speak on behalf of the river. If bodies of water are granted legal personhood, this allows for vulnerable communities, such as Native tribes, the ability to speak for nature and to ensure clean water for their communities. It is not a cure-all solution for climate change or Indigenous welfare, but it can be a step forward in protecting the interests of Native tribes and the world around us.